Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull & Estate and Succession Planning. You're listening to episode 211 of our podcast. Hi there, Ian.
Hi, Suzanne.
How are you today?
I'm good, and you?
I'm good, thank you. You always stumble on that one, don't you?
I do. It's a pressing concern of mine always.
Sure it is.
All right, let's move on to our podcast, our mini-series on administration and estate administration and the kinds of things you can expect should you have the joy of administering an estate.
And we started with a little bit of the background and a fact scenario of the last podcast, and we set up a situation where we've got someone who's going to see a lawyer with a will in hand and wondering what it is that an estate administration actually entails.
And we have that person is there on behalf of his uncle, which has just passed away. So we'll try to dovetail that fact scenario into all this. All right, we talked at the end of it, we finished up saying, okay, after getting the core information, let's make sure we've got the vital information of what wills matter or what codicils exist and so forth.
And one of the things that we just wanted to add to that was the fact that when you apply for probate and you take this document to the court for validation, one of the things that you're required to provide is an affidavit of execution. And that affidavit is an affidavit that's sworn by the witness to the will saying, I was there, I saw the document signed, and it was signed properly, essentially. And that document is really important to the court and hopefully something that you'll find with the will when you go through that whole process. Now, I just thought we might take a few minutes and just talk about what happens if you don't have that. If you don't have that affidavit of execution, what then do you have to do?
Well, I'll look to you to answer that. Because I know what I would do. I'd run out of the room crying. No, I'm just kidding. What do you do? No, seriously though, what do we do if we don't have the affidavit of execution?
Well, in that case, what we're going to do is we're going to have to actually locate one of the witnesses to the will and have them swear an affidavit along the same kind of lines to the effect that they were present when the testator signed the will, that they signed at the same time in the presence of the other witness and the testator at the same time, and then that document will be filed with the probate application with the court.
And then the one layer more is if you can't find the witnesses, what do we do? And that's where we get what we call a banker's affidavit, or an affidavit from someone who can verify the signature of the deceased.
Right.
And that's sort of like the last tier down, although there's more tiers down, but we won't get into every doomsday scenario, but that's another way that we can chase down that information. And what's important, why it's so vital, is of course, in Ontario, not every province though, of course, but in Ontario, we have such strict requirements for execution that this document, this affidavit of execution, becomes a vital, almost deal-breaker document, certainly a deal-breaker document to get probate.
That's right.
Okay, so we've got our will, we've got our no codicil, we've asked, and there are no codicil, no handwritten notes. We open the page up, the first page, and start reading. And what are some of the issues that start to concern us?
Well, first of all, we want to see what the executor appointment actually provides, whether it applies to specifically that individual who's sitting across from you, or that individual jointly with someone else, or jointly and severally with someone else. And so you want to make sure that you're dealing with the person who actually has the authority as they're named in the will.
All right, and the question, of course, ties into who the individual is, and in our scenario, the nephew has come to see us, and uncle has died, and the nephew lives, let's just add another layer to the facts, the nephew lives in Florida.
And so another part of the fact-finding process is to get all the specifics about that individual. So we'll need his or occupation, his place of residence, the address, contact information, phone numbers, that kind of information is really going to be important for the probate application.
And in your last podcast, you mentioned the fact that we've got to track down names of beneficiaries, ages, dates of birth, and contact information. Again, hoping that our client has come with that. If not, we're going to send them back to pick up the pieces issues in that regard.
That's right. And one of the easy things, of course, is to identify the minors, because we all know that at a certain age, in whatever jurisdiction, they're going to be qualifying as minors or as adults if they're over that age limit. A more difficult thing that we have to press with our executors is capacity issues, because we've got requirements certainly here in Ontario that if a beneficiary is not capable within the meaning of our legislation, then we have to serve the Public Guardian and Trustee's Office or similar government agency on behalf of that incapable person in other jurisdictions.
Well, it's a really good point. When you're pulling the information out of your client for just what you think is basically clerical, contact information, we have to remind ourselves that we've got to dig down a little bit and just find out, okay, are there issues of capacity? Are there issues of them being minor children and things like that? Are they 17? Are they 16? And you don't put your mind to it. Just so that we can make sure that the ultimate goal of a smooth application for probate goes through without any glitches.
That's right.
All right. The other thing is, of course, in terms of the administration, and when you ask for this information or not is up to the individual lawyer, but sometimes I like to press at this point too, is that once I've got the core will and codicil or not codicil in our case, I like to also press in terms of who was, if anyone, a power of attorney for the individual before they died.
And why do you do that, Ian?
Well, I mean, the truth is that as executor, you're charged with the obligation instantly on the moment of death to bring in the assets of the estate, pay the liabilities, and distribute. One of the problems that can arise is if someone else was the power of attorney, and they have basically been the executor for the deceased for whatever period of time, you have to cooperate, and you want to cooperate legally, but you have to cooperate in terms of the transition, the flow of information, so that you're dealing with the starting balance that is accurate from your administration forward.
And as part of that process, there's really two options, and one is that you can compel that power of attorney to pass their accounts so that you've got the sanction of a court order saying that this is the starting balance for you as the executor, picking up the end of the administration of the attorney, or you can try to do that on a consensual basis, provided that you have the consent of everyone with an interest in the estate who is capable and of age.
And that is often the case. Most of the time you're able to sort of smoothly transition the good work of the power of attorney into the estate, and then at the end of your estate administration steps you're able to get a release from the beneficiaries who will say, look, you did a fine job bringing the assets in, including the assets that were under administration by the power of attorney.
That's right.
All right, so we've got ourselves in a good starting point. What's another twist once we're reading through the will that we want to, in terms of information gathering, that we can do, and maybe the client won't do, but we may have to do our own digging on?
Well, in many cases we'll see gifts that are made to charities or charitable organizations, and unfortunately many times too we'll see improperly named or not as carefully named institutions or charities as we might like. And so to the extent that we can get information from the executor about who the ultimate intended recipient of that gift is, that will certainly help us to determine who it is that was meant when they have an improperly named organization.
And we talk a lot about that in some of our previous podcasts, but that what we can do when we have a name that isn't correct and what the steps are taken under the Cypre rules and so on. In Ontario, we have a very streamlined process that we've been able to create statutorily, so we're able to fix some of the typos or the wrongly named charities fairly quickly. All right, well, look, before we wrap up, then we've got really our ducks in order to the starting point, but of course we haven't even begun the important thing, and that is how much is involved and what's going where. So the estate assets and bringing in the assets, we'll talk about it in our next podcast.
Great. Thanks very much, Ian.
Thank you.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.